Good evening, everyone. Locus standi is a Latin phrase meaning a place to stand. The locus standi means the right to bring in the legal paradigm. Locus standi means the right to bring an action to be heard in court or to address the court on a matter before it. Okay, so that is locus standi. Under the traditional rule of locus standi, a person could seek direction under Article 32 of the Constitution of India only in case of infringement of their legal rights by either the government or any other public body charged with statutory duties. Such legal rights must either be personal or individual. That is, the person aggrieved or affected alone could maintain a writ petition in case of infringement of legal rights. That is the traditional rule. The Supreme Court under Article 32(1) can devise any procedure appropriate for enforcement of a fundamental right. And Article 32(2), Section 2, the court has gives the court an implicit power to issue directions, orders, or writ necessary in a given case. But the problem is that the Article 32 of the Constitution does not actually prescribe who can seek legal remedy for their grievances. The traditional rule has been that only a person whose own right is injured is entitled to seek a remedy. This actually gives rise to three situations or three propositions of law, as they call it. One is that only he can take recourse to the writ jurisdiction whose own legal rights of person or property are directly injured. Two, when a person suffers along with other members of the public by administrative action, he cannot challenge the action in question unless he can show some special injury to himself over and above what others have suffered. And another one is that where a person challenging an administrative action is a total stranger, the court will not ordinarily entertain his petition for the reason that the third parties who have no interest in the case should not be allowed to take interest because they could drag the case unnecessarily. So, but this leads to a couple of unfair consequences. One, in some cases there may not be anyone having a standing to challenge an action of the authority, and thus the concerned authority may continue the wrongful action. The public injuries resulting in mass suffering may remain unredressed because no one has standing to seek judicial remedy. And also in a country like India, because of issues like poverty, ignorance, illiteracy, fear, etc., the poor are generally unable to seek redress of their grievances. They are unable to seek access to the court not because of the doors of the court are technically closed to them, but because they themselves are not financially able to do so, and therefore they continue to suffer the wrong. So there is a need for widening the definition of locus standi. Dehradun quarrying case can be quoted as one of the early cases of liberalizing locus standi in the early 1980s. In Rural Litigation and Entitlement Kendra versus State of UP, a letter from Rural Litigation and Entitlement Kendra alleging illegal limestone quarrying was treated by the court as a petition. And recognizing the citizens' locus standi, the court observed that preservation of the environment and keeping the ecological balance unaffected is a task which not only governments but also every citizen must undertake. The liberalization of locus standi took a sort of definitive turn in the wake of Bhopal gas tragedy, when the government of India passed Bhopal Gas Disaster Processing of Claims Act 1985. The act gave power to the central government to represent all claimants in appropriate forums. Litigations with public interest or social interest as the prime motivating factors are important, and courts started promoting such litigations for the benefit of the public. An example is in the case of Jayalalitha versus Government of Tamil Nadu. The Supreme Court held that any taxpayer in the state has a right to challenge misuse or improper use of any public property by anyone, including the political party in power. In 1997, the Government of India had constituted a high power committee with Justice Bhagwati and Justice Krishna Iyer to look into widening the scope and definition of locus standi. The committee had emphasized, the committee in its report had emphasized the need for making the rules of locus standi broad-based, and said that any organization or individual must be able to start such legal action. In the process of liberalizing the rule of locus standi, the courts have allowed even a prisoner in a jail to file a petition on behalf of inmates for violating their rights. In Sunil Batra versus Delhi administration, Supreme Court had accepted a letter addressed to it by one Sunil Batra, who was a prisoner in the Delhi Tihar jail, complaining that the jail warden had subjected another person serving life term in the same jail to inhuman torture. The legal basis for the development of the public interest litigation, as we call it, is derived from Article 32 of the Constitution. Under Article 32, the Supreme Court has original jurisdiction over all cases concerning fundamental freedoms enumerated in Article 14 to 32. To sum up, the current position is that petitioners have locus standi to file the petition, though they cannot be described as even though they are not an aggrieved party, or they cannot be described as aggrieved parties.